State Senator Paul Campbell has had his DUI charge dismissed. In this edition of Quintin's Close-Ups, I sit down with his attorney, Andy Savage, one-on-one. And be sure to download the free Quintin's Close-Ups app in your Apple or Google Play stores. Mr. Savage, it's so good to see you again.
Always good to be with you.
I appreciate this. Let me jump into the obvious.
Best newscast in Charleston.
Oh, thank you. I thought you had the best back in the day.
Oh, that was a long time ago. That was black and white TV.
Yeah. But, hey, let's talk about news. I want to jump into the obvious, and this is from the Somerville Journal Scene. It reads this: DUI charge against Senator dismissed. And the article goes on to say this: the day before Senator Paul Campbell was to stand trial for a DUI charge, a judge has dismissed this case, according to the Post and Courier. Tell me why a day before in your mind?
Well, instead of a day before, it should have been the day after. It should have been dismissed on November 5th, the day after the arrest, because the arrest was wrongful. This whole issue where they take a person who's a public servant and they treat him differently than they would you or I because of not what he did, but because of the position he holds, is terrible. In the old days, and I understand why people are upset, there was a time when if you were the state senator or you were somebody in public office, you'd get the breaks. You'd be given privileges that the ordinary citizen wouldn't be given. But those days are over. Now it seems that people, once they get a little something on a public servant, somebody who's has notoriety, who's in the public mix, the slightest little ding they try to exaggerate and really put the pressure on somebody. This was an awful case for Senator Campbell. Now I got to tell you, I have no personal relationship with Senator Campbell. I'm not an advocate of the Republican Party. I have no vested interest personally for him, but he to me is just a client, just like anybody else would be. This charge of lying is outrageous. And I immediately wrote to the Department of Public Safety and I said, this is wrong. You know that this doesn't apply in this situation. Senator Campbell gave his driver's license, identified himself, and they make a big to-do about the fact that he gave this young woman one of his business cards that said Senator. Well, his license plate said Senator.
Right.
And it's just kind of making this up to be something that it's not. And as far as the DUI goes, there was no basis for it. DUI requires you have to show who's driving the car to begin with. And number two, that you have to show that the driving itself was impaired. So you have to have crossing the center line. In this case, they had a very minor accident that could be very well attributed to the traffic flow. This was a night of the fair, right by the fairgrounds. It's stop and go traffic. There's 3 lanes on the highway, 65 miles an hour, and you have a very minor accident. They didn't give Senator Campbell the field sobriety test. They gave Mrs. Campbell the field sobriety test. And then when she passed the field sobriety test, they gave it to Mr. Campbell. But, he's 71 years of age. They have him walking. You see it not during the test, but you see him walking by the side of the highway. He works perfectly. We have film of him leaving the marina where he walks 400 yards on a dock, stepping over cables and ropes and whatnot without the slightest indication of insobriety. And yet they give this so-called field sobriety test. Notice how the officer, the young Marine, walks perpendicular to where they asked Senator Campbell to walk, and the cars are whizzing by at 70 miles an hour, right next to him. Of course somebody's not going to be able to walk a perfect line, toe-to-toe, whatever they had him do. But you also notice they didn't give him any cognitive testing. What do I mean by that? What they gave him is a 71-year-old man. They told him to hold his foot in the air for a certain number of seconds and to walk heel to toe on this highway where the pavement is is cracked and whatnot. But they didn't ask him to do what, say the alphabet or do anything of a cognitive function. So it was really just an unfortunate experience. I attribute it to the climate today that if it's a person of notoriety or a public official, that they're treated differently. If this was ordinary Joe, this would never have happened.
Okay, I got a couple of questions here.
Don't like my answer, huh?
No, I'm staying out of that. I just want to ask some sensible questions here.
You always were a prosecutor.
Okay, should it be Miss Campbell in front of the cameras talking about this situation and saying, hey, was this a DUI? Let me ask you this. Was this DUI or was this him lying to the authorities?
None of the above. He didn't lie. He told the truth.
Okay.
They charged him with lying. It was a false charge. It was dismissed. As soon as a prosecutor was finally appointed to the case, and that took some time. In fact, we didn't even know that who the judge was for some period of time. But when the prosecutor, who doesn't know me, doesn't know Senator Campbell, doesn't know anybody about anything, read what had happened, she said, Andy, I'm going to dismiss this charge. And I wrote to the highway department asking them, because that's the officer who wrote the ticket, to withdraw that immediately. And why did I do it? Number one, it was a false charge. And number two, if you call somebody a liar over and over again, and if it's in the media that this person is a liar, some people are going to believe that. And it's like that advertisement on CNN, with the apple. If you call an apple an orange or banana or whatever it is, and after a while people start to think that the apple's a banana. But they didn't do it. But they're going to have to answer in the court. This isn't over. When this happened, November 4th, the next day, the highway patrol gave all of you in the media the video, the incident report, statements that were made, and refused to give me any of those as Mr. Campbell's attorney for 6 weeks. They denied me access to the same material that they were giving to the media. So the whole idea that they had, including the denial of the blood test, was they were going to spread negative information about Senator Campbell. They weren't going to allow me to see what the evidence is that supported their charges. I mean, it's just outrageous. So I have filed a suit on behalf of our investigator against them, and we have a hearing later this month. It'll be interesting to see what they have to say.
Did they give Miss Campbell a blood test?
No, they wouldn't give anybody a blood test. Here's what they did. They said, you're a nice fellow, and these are your rights, and we're going to give you the breathalyzer. I know that you have a particular illness that the breathalyzer may not be accurate on, and because of the problem we've had with this breathalyzer, with the particular medical condition you have, we're going to give you an opportunity to have a blood test. And then when the information came back favorable to their case, the .09, which is barely above the legal limit, they said, oh no, we don't need to give a blood test, we got the information now. It's outrageous. Terrible what they did.
6 weeks. During that 6 weeks, what was it like for you to be an attorney trying to basically get through all of this information?
Well, it's just frustrating, right? These people, the attorneys representing the highway patrolmen, have the same obligation that I do, is to be forthcoming and to tell the truth. So that's why I, as a lawyer, not as a lawyer for Mr. Campbell, but as a lawyer, I'm not going to give up on this. Because if they can do that to Senator Campbell, what can they do to the fellow or woman in our community who is arrested and doesn't have the resources that we have? So, am I in favor of drunk driving? Hell no. You know, me, my wife, my family, my friends live in this community, and I don't want them harmed by a drunk driver.
Right.
But don't pick on certain people to try to make a big deal out of something that is not unlawful.
Was Miss Campbell under the influence of alcohol that night?
No, I mean, they gave her the field sobriety test. In fact, they gave her a lot more than they gave Mr. Campbell in terms of the field sobriety test, and said, oh, she was fine. And when, you know, it's funny, you look at that video, I look at it different than I guess the ordinary person would. When Miss Campbell takes the field sobriety test, she does it barefoot. And the trooper knows that she's barefoot. And he tells her what to do. When she passes the test, and she's walking back to her car, he says to her, let me hold my flashlight here because there's glass all over the ground. I don't want you to cut your feet. Well, why didn't you think about telling her that there was glass on the ground when you had her do the field sobriety test? You know, why didn't you say the same thing to Mr. Campbell when he was doing the field sobriety test? I mean, the whole way it was carried out by these particular troopers was pretty outrageous.
What is the state of the South Carolina Highway Patrol in your mind right now? How do you look at them differently after this case?
Oh, I don't think that you condemn everybody. You know, I have, as you know, a lot of respect for law enforcement,
Right.
and I deal with law enforcement all the time.
Sure.
But people in our community have to be treated fairly, and they have to be treated equally. That's my deal. Everybody has to follow the rule of law. Quintin does, Andy does, the troopers have to. If we start bending the rule of law, you're going to wind up with a chaotic society. Everybody has to be fed from the same trough. Everybody has to eat from the same spoon. Everybody has to follow the rule of law. And they didn't follow it this night.
Did he?
Did who?
Paul Campbell.
Yes, absolutely. To the T.
Okay.
You know, we don't go out and arrest people because they're the big fish. You know, you don't see on the license plate senator and say, well, I'm going to treat him differently, either better or worse. Everybody should be, must be, treated the same under the rule of law.
Was the victim treated fairly that night, in your mind?
Yes. This was an automobile accident.
Right.
It was a very minor automobile accident. This, as you know, you've been in the news business for many, many, many years. This would not have been newsworthy but for the title before Campbell's name. You wouldn't have on Channel 2, 4, and 5 a 50-cent wreck case where nobody was injured, that there wasn't any damage to the car that prevented them from driving away. This was a bump. This was not a crash. This was not something that disabled, broke headlights, there wasn't any of that. There wasn't any body parts that from the vehicles that fell down on the street that had to be swept up or cleaned back. This was a bump.
So basically you're saying essentially this was a minor accident. This was not about DUI nor false information.
No, I'm not saying that.
Okay.
I'm confirming that.
Okay.
Right? So I didn't create that fact that there was no unlawful activity. I'm confirming the fact that this was a 5 mile an hour or less bump, that nobody was injured, no significant damage to either vehicle, no body parts from either vehicle were left on the ground. It was a nothing. And it just got built up because the Highway Patrol overplayed their cards. And the important thing, though, is in the end, justice prevailed, the rule of law prevailed, and that Campbell was treated as any other citizen would have been in the same situation.
How is Miss Campbell doing right now in your mind?
Mrs. Campbell?
Yes, sir.
Oh, she's a tough lady. She's doing fine. I don't think, neither one of them, you know, that's the tough thing on the lawyer. You talk about pressure on the lawyer.
Okay.
When your client doesn't think they have done anything wrong and they actually haven't done anything wrong, the pressure is tremendous on the attorney to carry out the rule of law. Right. So if I had a client who was guilty or committed an act or admitted that, those are tough cases. But the really tough cases are the ones where you have an actual innocence on the part of the client, and then it's really up to you, Andy, as a lawyer, to show the court that your client is innocent.
And when you think of Paul Campbell's image right now as a person and as a state senator, what sticks out in your mind?
Public servant. Here's a guy who has his economic situation certainly doesn't require him to work at the airport as he does. It doesn't require him, I mean, he's retired, he's 71 years of age, he doesn't have to be in public office for any reason of economics or anything like that. He's doing it because he feels that he wants to serve the public. I can tell you, and I have to be careful when I tell you this because I have two hats, take a look at our airport today and compare it to what it was 8 years ago. Not only the physical plant, the beauty of this airport, that he is solely responsible for overseeing the construction of it, but peek a little bit underneath and see the management, the efficiencies that were put out there, the cost of doing business for the public. Look at the controversy that we were subjected to 8 years ago, constant controversy. It's gone. And I attribute that to Paul Campbell, who has been the director and who has done an excellent job in managing that airport, much as he managed business in his earlier career.
And has he been able to sit down, him and his wife have been able to sit down perhaps with the victim and say, hey?
He was never given that opportunity, but we have certainly communicated. First of all, he communicated those apologies immediately that night.
Okay.
And he has since, through our office, I've been in communication with the young woman's attorney. We've facilitated a resolution to the civil case, which we thought was important. It's not our money, it's not Campbell's money, it's the insurance company that has to ultimately make that decision.
Right.
But you know from your experience that civil cases in automobile wrecks, sometimes the insurance company doesn't want to write a check right away, so we facilitated that in an effort to make her whole. The young woman was, at this time of this accident, was planning her wedding. There were a lot of things going on in her life, and we wanted to make sure that she was made whole. And I think she has.
From November 4th to right now, if you could go back inside the courtroom and talk to the judge, what else would you say about this whole situation?
I would have asked, I was surprised that the court didn't accept this pretrial motion that we had filed a long time ago. Once we didn't file any motions until we got the information, right, from the state, the videos and whatnot. And once we got that, it was clear to us that the case had no merit. And we filed those motions. There was a hearing back in January, I think January 23rd. And the prosecutor agreed with us at that time. We thought that this dispositive motion, the motion that we filed that would result in either the case moves forward or it doesn't, would have been heard at that time. So this issue of, the last minute thing the day before the trial was about to begin, that's a false issue.
Okay.
This is a case that the judge in retrospect said that he should have made that decision back in January. But it's because I didn't explain myself well enough. I'll take the heat on that. And to point out to the court why he should have made that decision in January. So once he didn't make it, I got together with the prosecutor and said, let's move for reconsideration before trial, because we don't want to have all these jurors come to court, all these witnesses come. We would have had a multi-day trial. But for judicial economy, and to save the prosecutor, the state, and the defense time and money, let's have this issue heard, because I believe we'll win that. Now, the state of South Carolina, for 10 days after the decision is made, has a right to appeal.
Right.
So you keep your eye close on that, and you think If you think that the prosecutor feels that the judge was wrong, you know that they will appeal the decision. It's not going to happen. Law is very clear. The law goes back, there's case law going back to 1976 that we brought to the attention of the court. You don't see this very often because this type of case isn't made. You know, it's so clear to those of us in the practice of law that there was a mistake in the arrest of Mr. Campbell. That's why you don't have a lot of cases throughout history. But all the cases of a similar nature are very clear what the remedy is.
Did he have any witnesses on the night of that particular incident?
Yes, he did.
Okay.
We had, I think the news media knows where he was. We have video where he was that night that is very favorable to him. But we also have live witnesses of people who were with him and saw when he left this area who got in the car and which door. So, yes, we had a number of witnesses that would have been very helpful for us on the issue of who was driving. We have video that's very good on the issue of sobriety. Even the video that the state provided, if you go back and take a close look at it, you'll see the trooper and Mr. Campbell walking.
Right.
It's fine. It's only when he's given this test to put your toe here and put your foot here and you're walking on a crooked highway and what I mean is the surface wasn't level. It's not like walking in my office here, Quintin. It's on the side of a highway with cars zooming by 5 feet away at 70 miles an hour, blue lights going on. I know when I'm stopped by the highway patrol, and I have been, not in a while, my heart starts beating. When those blue lights go on, I don't care who you are, you still makes you nervous. So when you have a highway patrolman standing next to you and say, count to 10 or lift your left leg or lift your right leg, it's hard enough when you're 23, when you're 71 and you're in that particular location at that time, it's difficult.
Let's move from Paul Campbell to your other client, Michael Slaker. What is life like for him right now?
Quintin, I want to spend the day with you because I have so many good stories of good people to tell how they're doing, but Michael Slager's one of them. Cheryl and I went out to Colorado 2 weeks ago now. Shortly after he arrived at the designated facility, he is in a federal correctional institution, not some camp location where they have no fences, but he's in a very restrictive prison. The greatest thing about it is that its reputation for safety of the inmates is terrific. There are a lot of prisons, both in state and federal prisons, that are dangerous. They're all dangerous, but this particular one, he's in Englewood in Colorado, to a lesser extent the danger. There's some interesting people who have been there in the past. The Enron folks, if you remember the white-collar crime in Texas, the governor of Illinois, Blagojevich,
Right.
he just actually moved from that prison to another camp. Somebody who's there right now, you may recognize Jared from Subway fame. So the Bureau of Prisons has been very good to Slager in the sense that they've placed him in what I think is a very safe environment. Now beyond that, it's prison. So it's not a very pleasant place to be, any prison. It's a long distance from his family, so it's hard for his family to have regular visitation with him. And of course, I'm still very sensitive and upset and deeply depressed about the sentence that he received from this federal judge. I'll never get over it for the rest of my life. How a judge who is supposed to be fair and impartial and rise above emotion sentenced him to 20 years. and found him to be a murderer when a jury of Michael's peers immediately after a 6-week trial, in the 7th week, found him not guilty of murder. Jury found him of that. And that same jury who heard the same facts that this federal judge heard said, we can't convict him even of manslaughter. 7 of us think he's not guilty. 2 absolutely convinced he's not guilty of anything. 5 of us were leaning towards acquittal, and 5 were leaning towards manslaughter. That's a jury decision after listening and watching the evidence over that period of 5, 6, 7 weeks. The court then had an investigator, a parole officer, thoroughly investigate this case upside down and inside out and write a lengthy report. And this judge just threw it away. He threw away the decision made by people in our community, jurors in state court. He threw away a decision made by the probation officer of the year nationally who wrote the report. Threw it away. He threw away the statement that he made to me and other attorneys that this was not a murder case, that he said to us in chambers, and came out with this outrageous finding of murder. I will go to my last breath fighting that. It was an awful decision. In my 40-plus years of being a lawyer, this is the most outrageous, unconscionable decision that I've ever experienced.
Do you have the energy to really go back and try to get him freed or whatnot? I don't,
So, part of our defense was the truth of the fight. So, this wasn't somebody who was driving a car, got out of the car, and got shot in the back. That's murder. This is somebody who was driving a vehicle, was stopped for a very minor safety offense, very minor, something that he wouldn't have even gotten a ticket for, but would have been, like so many hundreds of others would have been said, sir, you need to go right inside this door here, get a 35-cent bulb and put it in your tail light. Repeatedly. I mean, we had hundreds of cases that Michael did that. But for whatever reason, the gentleman decided to run. He was followed. He didn't obey the instructions to stop. He not only didn't stop when he was approached by Slager to stop, to physically control him, he fought him off. And there's video of that. And yes, he did shoot him. And that's why Michael pled guilty, because he used excessive force to stop him. But he didn't murder him. So one of the things this judge said, which was shocking to me, is that he relied on his law clerks. He relied on Rob Dewey, who was a witness to this case. And he relied on his wife, who's a forensic pathologist. And in his words, to help me interpret the protocol for the autopsy. That's not how the system works. The system works that the judge makes a decision based on sworn testimony in the courtroom, just like the jury relies on sworn testimony in the courtroom. A judge doesn't have the prerogative or the privilege to talking to his wife, who's a specialist in forensic pathology. He doesn't have the privilege to talk to a chaplain who was a witness on the scene, doesn't have the right to have his law clerks who have spread the word around that they thought it was a murder case without looking at any of the facts, to rely on them to make a decision. So the decision to me is as outrageous as any that I've ever been involved in. And because of his reliance on those people, we are pretty optimistic that this will be reversed, and that the issue of his plea of guilty, we agree with. We're not objecting to the finding that he's guilty of excessive force. We're objecting strenuously to this court's ignoring sworn testimony that was taken in the courtroom and replacing it with the opinion of his law clerk, the opinion of Rob Dewey, the chaplain who was a witness, and relying on the expert testimony of his wife, who had nothing to do with the case at all.
Andy Savage, thank you so much for your time. I really, really appreciate this.
Glad to be here.
Thank you. I appreciate this.